But this is very okay. Let me get back to the introduction. She's about ready. But like I say, she's worked with the largest and oldest cooperatively owned organization whose membership includes minority farmers, black farmland owners. But we're extremely honored that you came out today because this is an investment. You're not only investing in yourself, you're investing in your children and your grandchildren. And my grandmother told me 40-some years ago, she said, honey, you can work all your life. You would never be able to buy what I left you. So once you lose your land, you lose your everything. You won't never be able to get it back. And that's money, that's wealth. It's already paid for. That's what I found out about a lot of the heirs. The land's paid for. So what's the problem? You know? And look, that's my sermon this morning. Sweetheart, you come on up here, baby.
All right. Okay.
Thank you for coming, sweetheart.
Oh, of course. Oh, thank you so much for having me. And I apologize so much for the tardiness. We drove up from Atlanta this morning, my daughter and I, and so I got stuck on 95. But I'm really excited to see so many of you out here. I've given these presentations to 2 people, so seeing how many people are engaged in making sure their family land is preserved really touches me. As was said by the introduction, I am an attorney. I'm licensed here in North Carolina. I started my career at a small nonprofit law firm based in Durham, North Carolina, called the Land Loss Prevention Project. So pretty much all I've ever done since I graduated from law school is work on these issues with heirs property and estate planning. So what I primarily provide are estate planning services, and I'm now with the Federation of Southern Cooperatives. We're having a little trouble with the presentation, but I'm with the Federation of Southern Cooperatives Land Assistance Fund. Thank you so much. And today I wanted to chat with you all and answer questions about heirs property, some of the resources that are available for folks who own heirs property, and especially estate planning, which is the only way that we have to prevent the creation and the ongoing perpetuation of heirs property. So the Federation of Southern Cooperatives, for those of you who don't know, is a 56-year-old nonprofit, and we are an association of cooperatives. We are actually chartered in Washington, D.C., and the charter that we have is no longer in existence, and definitely we haven't gotten really good cooperative enabling legislation passed here in the South. And so we kind of think about this as, you know, when they saw that the civil rights leaders and the Black cooperative development leaders were really looking to co-ops as a way that the community could own and control the ways that it provides for itself and owns and creates the wealth that it generates, there were lots of political forces that are always working against that. So that's our history, is that the leaders that were involved in the civil rights movement down in the South, a lot of them would rely heavily on farmers for bailing them out of jail, for trying to get folks registered to vote, and they just had really close relationships with rural communities. And so many of our first 22 cooperatively owned businesses were farming cooperatives, but we also had quilting bees and formal and informal credit unions, a lot of churches that had their savings clubs. So we have a long history of working with Black farmers, developing co-ops, and working with landowners. The majority of the landowners that we serve are heirs property landowners. Just wanted to let you know about some of the other services that we have at the Federation. So we do have a cooperative development center, and through that we help folks come together to form cooperatives so that they can have better access to markets, and we connect them to our regional marketing system so that they're having a market for whatever they grow. And last year I got the opportunity to go and help plant some watermelons, and it is very difficult, the machine that you have to put the little seedlings in. So definitely value your farm products, because it's very hard work. And we make sure that those farmers aren't just working in vain, that they do have markets that their products are going to. And additionally, we have our forestry center, our forestry work at our Regional Rural Training and Research Center, and that's located in Epps, Alabama. So our co-op members own an 1,100 acre piece of land. About 900 of that is a registered forest. So our members can come out and see some of the best practices. We have 4 Black men, foresters that manage our forest, and they actually show folks, especially heirs property landowners who have unmanaged forests, some of the practices that you can put in place. And those are kind of our conservation experts. They know all the programs at NRCS, and they help folks develop forest management plans. They'll come out anywhere in our region. I failed to mention that we serve all the states basically from, well, we're chartered in 16 states and Washington, D.C., but our primary membership is in South Carolina, south to Florida, and then west to Texas. And so our foresters will go out and they'll help any family at no cost develop a forest management plan. And that's something that we really try to push for our heirs property landowners, because there's lots of money and lots of resources available for conservation practices, especially right now. And then my body of work is in the Regional Heirs Property and Mediation Center. So I'm the Director of Land Retention and Advocacy. We have a center that if you own heirs property and there's any kind of dispute, whether it's amongst family members or a neighbor, we can mediate any kind of disputes at no cost to the family. We're the state agricultural mediation service provider for Florida, Georgia, Louisiana, and Mississippi, but we also work closely with other states. Because I'm barred here in North Carolina, I know tons of attorneys here as well, so we work with a network of attorneys in all the states that we serve. For a long time, I was the only attorney at the Federation, and now I have since hired 3 additional attorneys. So we have attorneys, 2 of which just sat for the bar in February. So that'll be Florida and Texas for us, and then we have another attorney that's licensed in Louisiana. So if you ever need assistance with regard to heirs property issues, mediation, or if you have interest in advancing your farm, I failed to mention that part of our cooperative development work, we also help families develop farm management plans. And those outreach specialists that we have, they'll go into the USDA office with you if you're applying for credit or any kind of programs through USDA. So wanted to just make sure that you all are aware of all the services that we provide. And the mission of the Federation has been the same for 56 years. We want to be a catalyst for the development of self-supporting communities through cooperative economic development, land retention, and advocacy. So these numbers might not be shocking to this particular audience, but I like to kind of start with a baseline of understanding. I'm not from this country. I'm originally from Jamaica, and there's a long story of how I got into this work. But I was really shocked when I learned about how much land African Americans had accumulated in this country. In 1910, that's considered the height of Black land ownership in this country. There were 218,000 Black farmers who owned 15 million acres of land, and this is according to the U.S. Census of Agriculture. However, by 1992, there were only 18,000 Black farmers remaining, and they owned only 2.3 million acres. So we've seen a 90% decline in both Black farmers and Black-owned land during that period. Another way of looking at this loss is in terms of farms that were lost. In 1920, Blacks owned approximately 925,710 farms. However, as of 2002, there were only approximately 29,090 Black-owned farms. And so that's a 97% decline in Black farm ownership in this country. And there are folks who will say, well, that's a pretty long time span from 1910 to 2002, and we've become a more urbanized, industrialized country, so we've moved away from farm production. However, there does appear to be a racial component to the rate at which land is being lost. And so from 1993 to 2003, we saw that approximately 94% of Black farmers lost part or all of their land, and that was 3 times the rate of white farmers. So even though we've seen farmland lost to development, we've seen farmland lost to urbanization, the reality is that there's still thriving farms, and there is a racial component to the ways in which and the rate at which our community is losing our land.
are they selling it or someone taking it?
That's a great question, and it's a combination of those two things. And I think that one of the slides specifically addresses that question. But yes, there's a history of both sales and theft, quite frankly. Just wanted to start out with heirs property, although I'm sure everyone in this room knows what that is. The Federation actually is a part of our history. So, you know, our full name is the Federation of Southern Cooperatives Land Assistance Fund. And that Land Assistance Fund part of our name was the result of a merger with the Emergency Land Fund. And the Emergency Land Fund was the first organization to conduct a congressionally funded study on heirs property. And that was over 40 years ago. And not very surprisingly, those 19 recommendations that policy paper produced weren't really given that much consideration over the past 40 years. And unfortunately, it wasn't until very recently that heirs property has started to become something that is becoming invested in terms of families understanding and appreciating the threat of losing heirs property. But what heirs property is what results when a landowner doesn't leave an adequate estate plan. So sometimes you'll hear folks say when a landowner doesn't leave a will. But sometimes, and this is a challenge with our community in particular, folks want me to draft a will that says, I leave my house to my 4 children equally. And you know what that will just created? Heirs property. Because the same issues where they all own it, but who's making sure the taxes are getting paid? Who's making sure the insurance is getting paid? Who's going to go to court if somebody slips and falls on the stairs and make sure that the property isn't held, there's no liability for the owners of that property. So some of the considerations, you know, folks will look at those who've come before us as not leaving an estate plan. However, are you working with an attorney that can understand and anticipate those issues so that they can advise you to avoid the creation of heirs property? Because when you don't leave an adequate estate plan, then the state has intestacy laws. Every state has intestacy laws, and they're different from state to state. And what that intestacy law will say is who the legal heirs are and exactly what they get. So in Alabama, for example, the way that it's broken down is a surviving spouse would get the first $100,000 of value of the estate, and then they share the remaining value with any surviving children. So in North Carolina, there's a different math that doesn't include the valuation. It just says that the surviving spouse will get 1/2 share, and then the surviving children or offspring would share the remaining half across themselves equally. But what they own is an unfractionated interest in the entirety. So what does that mean? It really means that they all own the whole pizza together. They all own all those slices together. None of them can individually sell the entire pizza. They can just sell their slice. And that example is a little confusing because what sometimes happens is folks will come in and they'll say, you know, me and my 5 siblings, my father passed away without a will. Me and my 5 siblings, we each own 1 acre of the land he left. No, you each own 1/5 interest in 5 acres of land. And the way that affects the management of the property is that's how much you owe for taxes, and that's how much you're entitled to in the distribution of any profits that are made from that land. And that's a huge source of dispute amongst families, because a lot of families here in the South will say, well, I'm the eldest sister, so I get whatever rents are paid for this farmland, I get it. And then whatever's left from me paying the taxes and me managing it, I may share some with my siblings. Does that sound somewhat familiar? That's kind of just how folks look at these things. I'm originally from Jamaica, and I can tell you, like, it's black folks everywhere we are. That's how we still have those traditional values. So when you're an attorney coming into those situations, it's really, part of it is needing the mediation to help folks understand what their rights are as legal heirs, who the legal heirs are, and what their responsibilities are as co-owners. So what are some of the causes of heirs property? So we've already talked about limited access to legal services. when I started my career, you could not get paid to do estate planning as an attorney that was working in low-income communities, because they felt that if you were rich enough to own property, then you're rich enough to pay for an attorney. And so it's only very recently that you see some of the legal aid organizations and some of those firms that offer sliding scale will actually consider working with heirs property landowners. For a really long time, it was just kind of off limits. There's also limited access on the consequences of heirs property. There's some folks who say, I want to keep it as heirs property because it makes it harder to sell. I've heard that a lot. It's not true, but it's a commonly held opinion that if you have the tangled title, then it's going to be harder for that person who wants to buy it to find all the heirs. That's not true, but it's something that people often believe. Difficulty affording the necessary services, as I said, getting the legal services, affording mediation, getting everyone on the same page and having a contract for how we're going to deal with the property as a family. That's oftentimes pricing folks out of their ability to have those services. And so that's been a challenge. And then, of course, competing priorities. No one wants to talk to an estate planning attorney until they feel like they're right on the edge. They're right on the edge of going over to the other side. There's this fear in our community that once you sign, I've drafted entire estate plans, driven from Durham all the way out here, and had the person say they just need to think about it a little bit longer. So there's just other priorities that folks have, or just sometimes some superstitions around getting your affairs in order. So that can be a barrier to them seeking the necessary services. So what can happen if you just leave the land as heirs property? So like I said, there's a fractionated interest. So all of them, they are owners, they're co-owners. In the law, they're called tenants in common. And so the smaller your interest, the less likely you're going to want to be responsible for the management. If you own a 1/17 interest in 40 acres of land in Mississippi, are you sending a check for 40 cents to your uncle every year? Like, probably not. So it does create a situation where the more heirs there are, the less incentive any individual heir has, because what they would get if the property's lost could be just a really small amount of money. So there's not enough incentive for the family to come together. And so that fractionated interest issue is a big driver of the loss of heirs property. Tax foreclosures is way up there. So I just had a family about 2 years ago. The person that was always paying the taxes and maintaining the property, they died due to COVID, unfortunately. And now their spouse was trying to figure out, like, how do I do all of this now, right? Because now there's 6 other family branches that I have to collect the taxes from, and if there's a timber sale or something to divide the proceeds amongst, it can be very complex to make sure the taxes are paid timely. And some folks aren't aware of some of the things that you can get to reduce your taxes if it's in agricultural production. So tax foreclosures often occur when the family is not in communication with each other and everyone's not paying their fair share of the taxes. Limited resources, obviously, the less that you have to just cover your daily needs, the less likely you're going to be thinking about this family land that you might not actually have that much interaction with in your regular day-to-day life. Again, competing priorities, faulty or false court filings. This is unfortunately a common one. This is actually a common way historically and probably still now that folks exploit heirs property landowners, because as I said, the less people kind of keeping track of what's going on the record, of what's going on the property, folks are trespassing. What you'll see sometimes is someone just encroaching just a little bit on the boundary, and then just a little bit more. Next thing you know, years pass and there's a whole adverse possession based on a filing of something that they were claiming half of that land, right? So you want to check the boundaries, making sure no one's on your property trespassing, doing anything that claiming themselves to be the owner, because over a period of time they can get that legal right to own it. And then partition sales. I'm not sure how much that makes it out into the community discussion, but partition sales was a huge driver of the ways in which folks lost their land. So this answers both parts of your questions, actually, because partition sale most times is a forced sale. So the family sells the property, but usually not of their own accord. One of my first legal cases here in North Carolina was a woman who was living on a family's 100-year-old farm that she was born on, and a timber company had contacted one of her other co-tenants, one of the other heirs, and this person didn't have a relationship with them because, you know, families spread out and different branches go in different directions. So this heir that she had no relationship with sold their interest, and it was a nominal interest in the property. Well, what the timber company went to the judge and said, it's called a petition for a partition. So they petition the court, and they go to the court, and it's a very sympathetic argument that they make. They say, Your Honor, I don't know where all these people are. Like, I can't even keep track of all of them. Can you just give us a partition? The court's default is supposed to be what's called a partition in kind. That means they take the plat map and they draw boundaries, and then they give each person a deed that matches with their description on the map. But as we all know, the value of land is dramatically different from the road fronting piece, the landlocked piece, the water access piece, right? So the judges would have this challenge equally dividing the property, especially if you have a 1/17 interest in a 4-bedroom house. Like, what does that look like? So then the judges would order a partition sale. And what those land speculators would do is a buddy might be the one to buy the interest, and then this other buddy goes and buys it at the partition sale on the courthouse steps for nothing, less than the tax value sometimes, right? So that is a way that has been and continues to be exploited by those who are paying attention. They know what heirs property is, and they know that there's this belief amongst people that it's more of a headache than anything else, and they take advantage of that. And a lot of the beachfront property that we owned fell prey to that. And so partition sales were a huge part of driving the rapid loss of the land that we owned. And what does that look like? And there's been lots of research trying to calculate exactly what that number is. And some good friends of mine, one in particular, Dr. Ryan Thompson, who is actually educated here in North Carolina, teaches at Auburn now. He conducted a study that finished last year looking at 13 southern states. And based on the data from the real estate documents and tax offices, they estimated that there's at least 1.4 million acres of heirs property valued at $15.48 billion. Now, he was more so looking at residential properties. So if there's other studies that look also at timberland, and I've seen estimates of over $28 billion of wealth is tied up in tangled title heirs property situations. And that is billions of wealth that our community cannot adequately tap into without these legal issues being resolved. So enter the Uniform Partition of Heirs Property Act, which North Carolina still has not passed. So you have an opportunity to affect this being implemented in your state. But in 2010, there was an effort by the Uniform Laws Commission. And what the Uniform Laws Commission is a group of mostly white attorneys that come together and they'll draft legislation that they think would make certain laws across the states more uniform. So Thomas Mitchell, who's known as, a very important figure, he was actually the one who did the majority of the drafting of the Uniform Partition of Heirs Property Act. And what this act does is it acknowledges, first of all, that heirs property is a significant issue for families, and especially the threat of losing heirs property to partitions. And so the law, what it does is it does a couple of really significant things. The first of which, it gives us a definition for heirs property. So a really good outcome of that was that FEMA, after Katrina and some of the other hurricanes, they would not give disaster assistance aid to families who had heirs property. If your name didn't match the name on the deed, Even if you could show that you were a descendant of that person, you could not get disaster assistance. Similar with USDA, if your name didn't match the name on the deed, you couldn't get a farm number. Without a farm number, you can't get any of the services from USDA. So this definition now is used in other agencies' decisions around how they interact with heirs property. So that in and of itself is a huge outcome from this piece of legislation. It also requires that all the heirs get notice, because these partition sales were happening with some heirs never even finding out that it even happened. And what the argument would be that we couldn't find everyone, so we published it, or we posted it on the courthouse, right? Who drives by their courthouse to see if there's pending litigation against them? So that's now a requirement, and that has created a huge speed bump for those folks who would otherwise just file one. As a matter of fact, it's not funny, but I had a landowner contact me. What they were trying to do was get rid of the other heirs, and they went and filed one, and then the court made them contact everyone, and they were like, well, we had no idea like how many heirs there are. Like, we're not going to be able to just like skate around the requirement of making sure everyone gets notice. The court's going to make sure that every legal heir is given proper notice, so that if they want to oppose that partition, they have that right to do so. There's also a mandatory determination of value or appraisal. Appraisals were never occurring. So when those sales were happening, if the family got some money after the debts, they had no idea if that was actually what they should have gotten. And so now, before a sale can take place, the family has to be educated on what the actual value is. And if the family ultimately chooses that they want to sell it, at the very least, we want to make sure that they're getting what it's worth for the value of the property. It also gives a process for giving the first right of refusal to an heir or a group of heirs. And this sometimes is used by a group of heirs who just don't know who the other heirs are, or there's a contentious relationship, and they can file one kind of proactively to give other parties notice, and then that way they can consolidate the interests among those who don't want to participate in managing the property. It's a very risky legal strategy. It is one that is used, though, and this at least makes sure that those heirs' right of first refusal is preserved. There's also the requirement that the court consider alternatives to the partition. So instead of just saying, this is too hard, we're just going to sell it and divide up the money, it also makes sure that there's a consideration given to the co-tenants' rights, and to make sure that they're not prejudiced by a decision to partition the property. There's considerations for a partition in kind. So what that means is that, like I said, taking the map and drawing the boundaries, what if there's a great house on the property and there's an emotional attachment? That's where the family reunions have happened every year. There has to be some additional considerations that are not purely financial when you're talking about the partition. And so sentimental attachment. This is incredible. As an attorney, this is really incredible, because this is not, like, in our capitalist legal system, this is not a value that's really considered in terms of real estate at all. So the fact that it's reflected in this piece of legislation is very significant, because we know that if your place means something to you, right? Like, I'm originally from Jamaica. My parents are there now for Easter, and they sent a picture, and it's like, it makes you feel something when you see home, right? So that matters. That matters, and it's hard to put a dollar value on that. But it's a part of your identity. It's a part of your family's history, and that should be considered. And then the open market sale. Like how I said, like, two buddies could get together and, like, seal the deal in private. Now there's public requirements of how the sale is conducted, and that's really the best way to get these shadows out in the light, and sometimes it scares them away. So this is a huge piece of legislation. It's been passed in the majority of states now. North Carolina, the last legislative cycle, couldn't get it across the finish line. Not exactly sure why that is when it's been passed in some of the other southern states, but it's definitely something that can go a really long way. And I'm going to switch to the heir property relending program, but if you're not in a state that has passed the Uniform Partition of Heirs Property Act, sometimes called the UPHPA, then there's certain programs within USDA that you can't get access to. So that's another reason for you to consider, if if North Carolina considers the UPHPA again in the future, and you're heirs property landowner, that could be another incentive to encourage folks to support that piece of legislation. So the heir property relending program, oh, thank you so much. Thank you. So the heir property relending program, remember when I mentioned that report from 40 plus years ago? This was a suggestion that was made 40 years ago, and it was not passed until the 2018 Farm Bill. So one of the things that teaches me is that when there's an issue in our community, there are going to be a lot of hurdles to getting to the other side of solving it, right? And we kind of have to stay diligent and on top of it. And as I talk about this program, you'll see that it's still a hurdle in certain ways. But the 2018 Farm Bill authorized the heirs property relending program. It also had a section that allows heirs to get a farm number from Farm Service Agency. So that's your ticket to get access to the USDA programs, which heirs property, if you were farming on heirs property, you couldn't take advantage of those programs before, and now you can. So the process that's laid out is that Farm Service Agency, which is a sub-agency under the U.S. Department of Agriculture, will pick intermediary lenders. Why intermediary lenders? Because the USDA has a really long history of discrimination against black folks, right? Like this is not conspiracy theory, like this is well documented both at USDA, and Congress has many, many reports and records that just show the ways in which black folks, whether they're outright denied the loan or they're given the loan proceeds so late in the farming season that they're never going to be competitive at market. There were lots of tactics that unfortunately continue to this day. And so an intermediary lender, the thought was that a black family might feel more comfortable working with a lender that's not USDA, especially given that history. So those intermediary lenders can apply for loans from Farm Service Agency of up to $5 million at a 1% interest rate. Then those intermediary lenders set the program requirements. So what's the eligibility, what's the interest rate, what's the application process, and then heirs are able to apply to these intermediary lenders for loans of up to $600,000. That $600,000 matches up with what Farm Service Agency has as a farm ownership loan. So that's why that number is $600,000. Now, what can those monies be used for? Just about anything except building new property or purchasing more land. They can be used for closing costs, surveys, title searches, legal fees, and intrafamily heir interest buyouts just means that my sister doesn't want to be responsible for my father's land anymore. I can pay her $6,000 and now I own both her interest and my interest in the property. And so that's been something that families have struggled to do because there might be a family member willing to sell their interest, but they're not just going to give it away, right? And so you can take out a loan to buy them out. And consolidating those interests is really the best way. The fewer number of people making those management decisions, the more likely they're going to successfully maintain that property. So currently there are only 3 intermediary lenders. The first of which is Akitan, which is a community development financial institution based in South Dakota. Each of the intermediary lenders are community development financial institutions, and CDFIs each have their own charter. So the Akitan charter restricts its loans to any improvements to Native American communities. So that's not to say that a black landowner could not apply to Akitan, but there has to be an obvious connection to how that property will benefit Native Americans. So if you're both Native American and African American, this would work for you. And I know there are lots of folks in North Carolina that are both. But outside of that, Akitan is redirecting those prospective borrowers to other lenders. The Cherokee Nation also has a CDFI, and this one is based in Oklahoma. Unfortunately, their charter is restricted to Oklahoma, so anyone outside of the state of Oklahoma can't apply to this Cherokee Nation CDFI. And the only other one that has been identified thus far is Shared Capital Cooperative. The Federation sits on the board of Shared Capital Cooperative, so we actually applied together. We don't have our own CDFI, and it is a white-owned institution. They don't really work with heirs property landowners. So we help educate them on the unique challenges that heirs property landowners encounter, and they're helping us develop the financial tools that we need so that we can have our own CDFI at some point. But for now, Shared Capital is really the only lender that is positioned to make loans to our communities. And their charter allows them to work in the states listed there: Alabama, Florida, Georgia, Louisiana, Mississippi, and South Carolina. That being said, they will make loans to members of cooperatives. So if you're a member of a cooperative and you're not in one of those specific states, there could be considerations that are made. However, they're not currently accepting loan applications, right? So remember what I said about the hurdles? This is yet another one. The program was authorized in 2018. It was announced last year. Shared Capital still isn't making loans, but that's not USDA's fault. That's actually the result of a Treasury Department regulation. That being said, institutional anti-Black racism is a very real thing. I encounter it a lot throughout my career, and I know you know what I'm talking about, but we're trying to get to the point where Shared Capital is actively making those loans the way that the other lenders have been positioned to do, because while there are shortcomings with a loan program, for the most part, heirs property is debt-free. You can't put a mortgage on unfractionated ownership situation, right? Because the banks don't want that type of risk, and that's why for a long time USDA didn't want to make loans to heirs, because who do you actually hand the bill? Who's actually going to pay at the end of the day? But that being said, what we have been asked to do, we are the technical assistance and outreach provider for the entire country on heirs property. And so we provide a lot of technical assistance to lenders who want to participate in the program, to USDA itself, to prospective borrowers, and just about anyone who's interested in this program. Me or anyone on my team we're happy to come out to group. I mean, this is a huge turnout. Like I was blown away when I saw this number of people. We'll come out to a family. I'm actually speaking to a family about this program on Sunday. And so I wanted to let you know that there's lots of other services we're providing, even if your family's not there yet to be able to take out a loan. We will help with completing applications once they're available. We will help navigating the loan process. We also provide phone and virtual meetings, and we're developing a series of educational tools and resources. We're actually going to be bringing on a PhD student from Tuskegee to help us develop our educational materials, and his supervising professor is one of these researchers who's put out lots of papers on heirs property. So he's one of the national experts on that, and this young gentleman is learning under that tutelage. So we're really excited to have him joining us. We also provide estate planning services, and we have an attorney referral network that extends to all the states that we serve, and are happy to make those connections as well. So you might come in thinking that you're ready for the loan, but you don't know who all the heirs are. You're not quite ready for a loan. We can still help you with all these other types of services to get you to the point. Ultimately, we want to see families clearing title so they can enjoy what their ancestors left them. So any of the technical assistance we can provide, we think, is a step towards that goal. So some of the activities, as I quickly mentioned, educational resources and training workshops. We'll also have a financial literacy, we do have a financial literacy training coordinator. And he actually works with families one-on-one and he sets up group meetings as well. So he can assist with budget planning, cost benefit analysis, and as I said, you don't actually have to be in the hopper applying for a loan for us to help you navigate some of that, the financial piece of it, because what we want to make sure is that folks are really considering, is a loan the right way for us to resolve this issue? It will be for some folks, and it won't be for a lot of folks, right? So we really want to make sure that the financials, especially what are you going to do to make money off of this property once you've cleared the title? Are you just clearing it for clearing title's sake? Or do you want to actually have something that the next generation can benefit from financially? Oops. We have land retention specialists that will be assisting with applications. In the meanwhile, they're assisting with developing family trees and making those referrals to our mediators. We have both staff mediators and a mediator referral network that we work with. Our attorneys and our land retention specialists can also do some very preliminary title searches as well. And I mentioned the Federation Fellows, those are our attorneys. We provide mediation services in the states. I mentioned we're going to be hosting wills clinics throughout the summer. We have summer law students that join us from Southern University Law Center in Louisiana, and we host these wills clinics in various states. We really want to provide as many services as we possibly can to the community. And as I said, we've developed an attorney referral network. And it's very responsive to what our members, you don't have to be a member of the Federation to use our attorney referral network, but our members are primarily Black folks from the South. They want Black attorneys. And so I'm very proud that we've been able to recruit a significant number of Black attorneys that work on estate planning and real property issues, so that folks are treated with the comfort and the trust that that relationship can create. So estate planning, and I'm gonna kind of fly through this because there's some things that I think we've already kind of talked through over the course of the presentation, and I think that you all probably know a lot more about estate planning than the other groups that I present this to, but it's really the only way to prevent heirs property. Unfortunately, I'm asked all the time, like, what can we just do to fix this heirs property issue? There's so many layers to it. There's the government's involvement. There's local bad actors' involvement. There's a whole host of challenges to clearing title. Like, there's no law that can be passed to just say everyone's title is clear, right? That's not something that can be done on a policy level. It's really something that, even though the family inherited it, it's really the family's individual situation, and every family is going to look at it differently. I have families that come to me, they just want to sell and not have to do. They don't have any interest in maintaining the property, and then I have others that are just desperate for whatever they can do to keep the land in their family. So estate planning, even if you already have heirs property, it's the way to prevent the next generation from adding more heirs to that number of that already very difficult number of people to rally together. This text is very small, so I'll talk through it, but the main documents that people hear about when they're talking about estate planning are a will and a trust. There's some variations, but in general, those are two of the main vehicles that are considered, and they're slightly different. A will, but they both serve a similar function. So the major difference between the two is a trust is going to be a little bit more expensive to set up. There's a couple of reasons for that. The level of attorney expertise that's necessary to draft a trust document is just higher. A trust is kind of like starting a business. So you're putting a fiduciary relationship between the person that's managing it and the beneficiaries of that trust. So that trustee, I have a family where the eldest sister has named herself trustee, and she's managing it to her benefit. And so I've been contacted by little sister who obviously has an issue with that. But really the person that's managing the trust, their responsibility is to make sure that they're not doing anything with the property. They're not advertising this family home as a Halloween haunted mansion. That type of thing will undervalue the property. It makes it more difficult to sell if the time comes. All the things you would want to do with property can be undermined if that person isn't making sound decisions. So that's another cost, is some folks elect to have a professional trust manager as opposed to any individual member of the family, just so they know that that person's going to objectively be looking at all the beneficiaries' interests. A will, you can actually draft your own will without an attorney on a piece of notebook paper, as long as you're 18 years of age, of sound mind, and there are 2 witnesses that won't benefit under your will. That's actually something that you can do. Would I recommend it? No. But that being said, not everyone can access an attorney. Not everyone has, the resources to do that. So a will is, there's a little bit of flexibility within the law of what folks can use as a will. But in the state of North Carolina, like I said, you just have to be 18 years of age, of sound mind, with 2 non-beneficiary signing witnesses to make it a will. The things that you want to make sure you're considering when choosing between them is the cost, but also a trust is going to be something that's effective as soon as you sign the trust documents. So it's immediately a trust as soon as you sign the paperwork. A will has no legal effect until the person has transitioned. And so that comes up sometimes if somebody is in a coma or a state of inability to manage their own affairs. And then there might be a family member saying, well, they said this in their will. A will has no legal effect until that person expires. So that's one of the considerations that should be a part of your estate plan, is how many documents, how many decisions do you anticipate your family needing to make? And can you trust any individual person in your family to administer the will or to probate the will? Or can you trust a person to manage the trust? So those are some of the considerations. But the biggest thing, if you are an heirs property landowner, you want to make sure that whatever device you use, whether a will or a trust, addresses your heirs property. Because what people usually do is when they're drafting their will, they're just thinking about their house, their car, their jewelry, like the finite things that they can see and control. And then what happens is they don't address the heirs property because it's just not front of mind. If you are a legal owner of heirs property and you don't address it in your will, any good will is going to have a clause in it that says what to do with anything that I forgot to mention. So there's a residue clause, a residuary clause. And that's another reason why I would say don't draft it yourself, but I digress. The residue clause is going to say, if there's something I failed to mention in this will, this is how I want that managed. So some people might want to have that go into a trust, or others might say, I want it to go to my church. But if you don't say with your residuary clause who it goes to or where it goes, then that's heirs property is dealt with the way that heirs property is dealt with as an intestacy passage, right? So there's still going to be more heir math that has to be done, even with your drafted will, if you're not deliberate about addressing your heirs property. And you can't just say my heirs property goes to so and so. Because some of us, especially those who have been in this country for a couple generations, you could have multiple interests in heirs property. So the court's not going to know which one. So the attorney that you're working with needs to be specific, have a specific legal description of what your interest is, your 1/17th interest in 40 acres of land in Alabama. Whatever one you're talking about, you want that attorney to address specifically. That's one of the things that I'd say with working with attorneys. You're doing it's not just they tell you what I tell my parents, it's not just them telling you, it's a conversation. They're not just telling you what to do. You're I know that you don't know what you're talking about if we're not addressing my heirs property, right? So you feel empowered to push back, because a lot of folks will say that they can draft a will because, like I said, a layperson can draft a will, but not everyone is going to think about that issue of heirs property top of mind the way that someone who is, working specifically with heirs property landowners would do. Other pieces of your estate planning toolkit. These I cannot stress enough, and I have always felt very strongly about these additional estate planning documents. Most of these you don't need an attorney for. In North Carolina, some of these there's actually like a statutory form that you can print off of the internet and just fill out. And especially living through this pandemic, I can't imagine like a more important time for all of us to have all of these. So a living will is the document that allows you the right to determine a natural death. This is one of those documents that folks come to me as their lawyer to tell them what to put in it, and I tell them to go talk to their pastor, because you have to decide for yourself, like, what are the limits of where that pulling the plug should occur, right? Only you can decide that. And it's truly a gift, having had to deal with this both personally and professionally. It's truly a gift to your family for them to have the peace of mind of knowing exactly where you would draw the line, because it causes a lot of family drama when, dad and kids don't agree what should happen to mom, right? So a living will is a gift that you give to your family to let them know when you would be at peace with that decision. Power of attorney, not necessarily specific to the estate planning circumstance, but it does come into play. Long-term care facilities almost always have you fill one out just to be admitted. And that's because there may come a point where you're unable to make medical decisions for yourself. So whether you want to have a feeding tube, or whether all of those other extra life extending I'm sorry, I switched to healthcare power of attorney. Power of attorney is the financial decision. So do you want your family to sell the house to pay for your end of life medical care? Do you want them to, take everything out of all of your retirement funds? Or what are those decisions, and who do you trust to make those decisions on your behalf? Usually it's a spouse. Sometimes spouses can't handle that responsibility because they're emotionally overwhelmed. So this gives you another chance to think about who can actually manage that responsibility. And then this is one that's going to be important for any kind of Medicaid. There are folks who are trying to strategically spend down enough of their resources to be eligible for Medicaid, all those types of strategies. And that's a tool that you would need for using insurance as a part of your broader end-of-life care planning. Healthcare power of attorney, which I accidentally slid into a while ago, is the one that allows another person to make medical decisions on your behalf should you not be able to do so. And it just doesn't have to be in a medical facility. It could be you're in a car accident and now you're in a coma. And so I try to explain that young people never want to hear anything I have to say ever. But that's one of the things that I try to drive home, especially to my friends of young kids, that you want to make sure that your spouse or your next of kin understands what medical procedures you're actually comfortable with, and some that you're not. So my mom and dad are like complete opposites. My mom's like, the minute that I don't look, my mom's very vain, like if the minute I don't look like me, like I don't want any life extending anything, like I'm ready to go meet my savior. My dad is like, if you don't do everything that's medically available at the time, I'm gonna haunt you from the grave. So we have these conversations very often. It's really important. I know it's not comfortable to discuss for most families, and I'm a weirdo, so we talk about it all the time, but many families are not in that position. Although I do think it's a part of stewardship. When I go to churches, I'm like, I really feel like this is a part of your Christian duty, but that's a side note. But that really does take that heat off of your next of kin. because I don't know if any of you have ever witnessed someone being intubated, witnessed someone getting end-of-life CPR. It's very traumatic. Hopefully you never have to see a loved one going through something like that, but any witness of it is very traumatic. And so to the extent that you can give them peace of mind to know, okay, like they wouldn't want to go, they wouldn't want 6 rounds of CPR. They wouldn't want XYZ thing. It's truly gives your family peace. So if you don't even consider the wills, like this is not legal advice, but if you don't consider either of the will or the trust, I highly recommend that you at the very least consider these. You absolutely do not need an attorney for these. And as I said, I think both of the powers of attorney you can actually find on the North Carolina state government websites. At least you could when I was, Mari's 9, so I haven't lived here for 9 years. But I do know that the state has an approved form that you can use. And I would, even if you are going to have an attorney draft it, I would still look at it just to see what conversations you want to have, because it asks like, is it when the heartbeat stops? Is it when the brain stops? Just things that you wouldn't naturally think of towards end of life. And those considerations, I always recommend speaking to a spiritual advisor in addition to your family, because those are all very personal. Like I can't tell any given person where to draw the line on what procedures to use, something that you want to think about. And almost last but not least, the Federation also has a National Heirs Property Boot Camp every year. This is going to be our 5th year, I think, and it's called Forward. So this year is called Forward 2024. Every year has the following year's date. So the one last December was Forward 2023, and what it is 2 days of workshops, trainings. We have our attorneys from our attorney referral network come and do consultations. I do a variety of workshops. We have a variety of workshops on everything from estate planning to just how do you communicate with your family to get on the same page about these plans. So there's a lot of really good information. I encourage families to come together so that Auntie so-and-so and Uncle who don't want to talk to each other hear the same thing at the same time. And that way there's no dispute about what the law says in your state, right? So we recruit 100 heirs property landowners, and we have 100 practitioners who include folks from USDA attorneys, tax advisors, all sorts of resource professionals. And the best thing that I think as an heirs property landowner coming to this is you get a book that has a 12-month checklist of all the steps you need to take so that by the following December, you could have worked towards clearing title. So in addition to getting that book, our fellows, land retention specialists, and our summer law student interns actually call like once a month, hey, you're working on your family tree, because we know that competing priorities, right? There's just too much else going on for you to whip out a book every month to make sure you're following the steps. And so we provide those resources. We also have some families who we meet with them monthly to mediate. And that just helps them stay on the same path, knowing that there's a neutral person here that's helping them navigate the decisions. And so that is always the first weekend of December. I highly, not just because it's my job, but I highly recommend it. I think that folks get a lot of value out of it. And with that, I'll open it up for questions. Now, my preface before I open it up for questions, because this is going to happen, but I'm going to say it anyway. Do not put your business on Front Street, okay? I always tell folks, because people will stand up and they're like, I have this aunt who this and this and this and this. You don't know who's in the room. My child could be a land speculator. She could go call your aunt and buy her interest, and now you have another heir. So I really caution folks, when you're going to ask questions in group settings like this, think about whether or not it's better to have a private consultation to ask your very specific questions, Because I really do mean it genuinely. Like, there are folks who attend meetings like this to take advantage of family drama. And it's not that I don't want to answer questions. I love answering questions. I just want to make sure that we're all on the same page. I don't want anybody's business out there.
Could you explain a little bit more about the trust and how that works?
Okay. So you can set up a trust for anything. This is the first thing. What a trust is a document that tells the parties involved who's responsible for managing that property and who the beneficiaries are and what do they get. So I'll have people that say they want to set up a trust because they've heard it's more durable or they heard it's better than a will. But then what would the beneficiaries actually get? If this is a house that's not generating income, what would be the benefit that the beneficiaries get? So you want to really, the starting point is, what is the benefit that the beneficiaries are going to get? What is it that you want to preserve for them to receive? And who would be able to be responsible for those decisions? So it's a consideration about who you can trust to make decisions about a piece of property, who, like, whether it's an individual or a professional trust manager. Who is it that's going to make sure that all the bills are paid, the taxes are paid, all the responsibilities of maintaining the property is going to be completed, and then exactly what you want those beneficiaries to receive. So a hypothetical could be that you set up a trust for your house. Some people actually do this just routinely, is that instead of getting the house deeded to themselves, they have it deeded to a trust. And they may do that for privacy considerations. They don't want folks to be able to look through the register of deeds and find their name, and it would have the name of the trust instead. So it's sometimes used as a shield in that way. But the bigger consideration for a trust is you want to make sure that you have a plan for what the benefits would be if they set it up for the house and you're going to make it a rental property or an Airbnb property. You're going to want the 3 beneficiaries to get 1/3 of the Airbnb profits at the end of the month. So that's what is that clearer, or do you still have questions about what a trust is?
It's clearer, but not.
Okay, yeah, it's a little bit difficult to explain because there isn't like a really good example of what a trust looks like. Because for example, if you have a minor child, you might set up a trust and just fund that trust with your life insurance proceeds or money that you inherited, a home that you inherited. That's what funds the trust. That's what's placed in the trust. And then the trustee has to make those decisions about the management so that that child's life can be paid for until they're 18 and they're old enough to manage it for themselves. So that's a situation where someone might use a trust. It's all just about putting a decision maker in charge of the property instead of it being yourself. Does that help? Okay. Yeah, it's not, and that's a little bit of why it costs a little bit more, because a trust, a person who knows how to draft a trust is like, it's a trust when you see it. It doesn't have to be 50 pages long. It can be like it can be as short as a will can be. But what's important for it is that it has to have a trust body, a property, or something that it's going to be funded with, whether that's money, property, beneficiaries that are named, and the proceeds that they'll receive, and who's going to manage the property. And so the document that creates that relationship, it wasn't doing that before. Turn this off. So those are the considerations. I had a family that was in Texas that wanted to set up a trust, and they were asking me, they were quoted like $2,500, and they were asking me if that's expensive, and I was like, that's not expensive. I mean, that's what a trust can cost, but what is it that you want to use it for? And they said, they just want to make sure that the beneficiaries have a trust. And then I was like, okay, what's the land? Is the land generating any money? No. So it's just a vehicle that's holding it for the beneficiaries. if that's your way to make sure that no one gets it that's going to sell in interest, that could be your reason for it. But does that warrant the cost of getting it set up and getting it managed if it's not income generating? That's part of the question that you have to ask yourself. And that's I'm trying to think of another way to like make it make more sense than that, but it's not always. I've heard folks say a trust is better than a will. I've heard even estate planning attorneys just blanket say that, and what they mean by that is who's going to be making the decisions. And a really end of life planning is mostly about decision making. So what is it that you need? Another issue is if you have a particularly litigious, or if your children hate each other, they can slow down the probating of a will. And in most states, there isn't a requirement for how long it takes to probate a will. So it could drag on and on and on. And there can be someone saying, a spouse, it's going to be a spouse of one of your kids, just so you know. Sorry to break your bubbles. But it's going to be a spouse of one of your kids. It's like, well, why does she get more? Like, I feel like we should be getting some of that. And then that's when the will gets attacked as possibly there's another will that was signed after that one. And maybe this isn't the final will and testament. And so a will is kind of susceptible to that because you're not there to explain to the probate court what your intention was, whereas that trust document, signed, done. There are also families with heirs property that use LLCs as a vehicle for managing that heirs property. But at the end of the day, that's yet just another business tool to use to hold the decision-making power within an entity. So a limited liability company or a trust are also recommended for the management of heirs property that doesn't have clear title, but they each have their own costs. An LLC is slightly more affordable to set up here in North Carolina compared to a trust, but then you do have to pay that annual filing fee. You have to make sure that those who are named as members of the LLC are involved in the management. So each has its own considerations, and your conversation with your family or your attorney is going to help you decide what's the best tool for you. I know there was another hand, but I don't remember who. Oh.
I was going to ask in regards to the boot camp.
Yes, ma'am.
Spoke of for December 2023. Where is that?
They're always held in Atlanta. They're always held in Atlanta, Georgia. That's where my office is.
Is the address and everything, or how do you sign up to come to that?
The best way to sign up, I'm hoping there's a sign-in sheet for this because I can send out our all of our offices have slightly different functions, but our administrative office in Atlanta, it's technically in East Point, Georgia. We're the ones that kind of plan the regional events. And so you can get put on the listserv with our communications director, and as soon as the application for the boot camp comes available, you'll get an email that notifies you about how to register for it. And
Is there a cost for attending that?
there is a cost, and I don't remember off the top of my head because I do a lot of fundraising to try to manage that cost for participants as much as possible. I believe we give folks the option of joining the membership for $50 and not having to pay the registration cost for the boot camp. But I think the cost is $250. It could be $350 though, because there was a period when I first came on, we were still in the virtual environment. So last December was my first one doing it in person. So that's why the numbers don't just like roll off my mind. But if memory serves, the registration for non-members is $250, and for members it's no cost. And the membership, to join the membership, is $50.
Thank you.
Mm-hmm.
Okay, bear with me. I have somebody on the phone that wants to ask a question.
Okay.
Somebody, they own property locally, but they're not in North Carolina.
Okay.
Yeah, hold on now.
Let me pull up my questions.
What's yours?
Yes, first, so to understand becomes the new deed, but you kind of answered that earlier. You said you can deed it to your trust. You can deed the land to your trust, correct?
That's correct, yes.
And you talked about how to, I'm just going to, and can a trust, once a trust is formed, it can't be dismantled in any way.
That's a great question. And yes, it can. There are revocable trusts, which I don't really know of a good situation to use one. But the preference for managing property is an irrevocable trust. And so that's probably why you've heard that you set up a trust and it can't be dissolved. But a revocable trust can be reversed, but an irrevocable trust, it's pretty much as good as gold in terms of the judge takes very seriously the drafting of the trust, and so they're really difficult to get overturned. They're almost not going to happen.
Question. So the follow-up question I have is, why would someone choose a revocable trust versus an irrevocable trust?
Right, exactly. I think that the reason people choose it is it's cheaper. Honestly, I haven't, in my 15 years, heard a good reason. In my 15 years of practicing, I haven't heard a good reason to have a revocable trust, because it kind of is like basically the same thing as a will, that it can be challenged. It can, there can be holes that get poked into it. It can get, taken apart by the court. Whereas an irrevocable trust it's not going to be subject to any of that. I think that the real decision that someone would make is the cost.
Okay, so I have two more questions. I hope I'm not taking other people's time. My mother's question was, if she goes into a nursing home, how does that affect the trust?
That's a great question. And there's a couple of different considerations around nursing homes. And a lot of times what folks are trying to do is make sure that they're eligible for Medicaid. So with Medicaid, as you probably have heard, there's a 5-year look-back period. So anything that you transfer out of your name within the past 5 years before you're in a facility, Medicaid can tab that for payment. So Medicaid, you may be qualified for Medicaid, but then when your estate's being settled, the nursing home could look back and say, oh, well, she just made that transfer of her house to her daughter within those 5 years, and then that conveyance can be challenged. And so there may be circumstances, if there's a trust that gets set up the year before you get admitted into a nursing home, that a judge may pierce for Medicaid reimbursement. I mean, the government wants its money. So there have been cases where a trust was not sufficient, and that's why the language of the trust is so critical. And that's going to also be another one of those things that it's going to depend on the particulars of what the needs are, of how it's worded. But there are ways to phrase the trust that make it more difficult to pierce that. It's kind of like, do you know about piercing the corporate veil? Like if someone has an LLC, but it's really just their own bank account, they're not using it for business purposes, the judge will allow their anyone that they owe money to go after the LLC's resources. There's a slightly similar thing that can happen with a trust, that if there are enough factors, timing is definitely going to be one of them, but a lot of times it's going to be the language of the trust document itself, whether or not that's secure enough to protect it from nursing home. But just to go into the nursing home, a trust, setting up a trust, let's say it's 10 years before you ever need to go into a nursing home, that's going to put, you no longer own it, the trust now owns it. So you can't change your mind and say, you put your house in trust, now you want to sell your house, but the trustee is like, that's not what's best for the beneficiaries. You want to sell your house to make these payments on nursing home care, the trustee may not think that's a good reason to sell the house. So, so those are some of the things that could become a problem, is if you put something into a trust, you legally don't own it anymore. The trust owns it. So exactly. So any of those, so it'll be deeded in the trust name. And so any of those last minute financial changes that you want to make, now a judge is probably not going to allow you to, as the person that's putting the investment into the trust, that's funding the trust. The court's probably not going to let you just break it if it's an irrevocable trust. So maybe if it's irrevocable, but like I said, that doesn't really get you where you want to go ultimately.
Okay, last question is, if you're...
1 second. Are y'all able to hear the question? I'm assuming you can. Like, everyone's just looking up here. I was like, should I be repeating it? But I feel like, okay, sorry about that.
Oh, so they can hear me?
They can hear you.
Okay, awesome. All right. The last question is, if, let's say you have a trust and you're deciding that you want to develop the land into something, right? And there is a surrounding land, it's maybe extra land that is in a trust. Is it a way to form relationships with some type of contractual bond with the trust? Or what would be, do you understand what I'm saying?
I think.
So if I have my trust for, like, let's say, 10 acres, and what I'm trying to develop really requires 15 acres, right? So then there's 5 acres that I would like to approach the landowners and say, hey, look, we're doing this, and we'd like to, you want to put 5 of your acres in that development, and I understand you have, whether they have a trust or not, is there a way to, that's beyond just asking them to sell the 5 acres to us? You get what I'm saying?
I do see what you're saying. So any decision like that would have to be made by the person managing the trust. So it would be their duty or their responsibility to have that conversation with the other owner. And that would, yes, you can continue to fund the trust after it's initially established, but just by establishing it as a trust doesn't give you any special advantage to get other folks to invest in the trust. There are times, though, where there's like a land trust, a conservation, there's a trust established for conservation purposes. And sometimes land trusts will work together to secure a piece of property for conservation purposes. But in terms of a private owner that has property that bounds a trust property, the trust doesn't have any special rights or anything to get that other party to work with them on, funding the trust with that additional 5 acres. Does that make sense?
I received my answer through what you just said.
Okay.
I would love to have a consultation with you. I know you talked about the consultation. Is there handouts and stuff? I'm sure you can give it to, you'll have a handout.
Yeah, there are handouts that are going around, and you can join our listserv. Our website is the best place if you want a consultation, and I'll say this for everyone's benefit. If you go to our website, www.federation, federation.coop, so federation.coop, and then on there you'll see there's a lot going on there, but look, you're looking for the land retention tab, and when you click the land retention tab, towards the top there's a intake form, and it's either for mediation or for heirs property land retention. Either way, it's the same form. You just click on the intake form, put that in, and then you'll be assigned to one of our attorneys to get more information about whether it's a mediation or a legal case that you want evaluated.
Okay, and I'm assuming that they cover North Carolina.
We do work in North Carolina. Now, I will say that because my hat has a lot of things on it, and I'm the only North Carolina licensed attorney. I do work with, we have an extensive attorney referral network here in North Carolina, but my first referral is always to the Land Loss Prevention Project, which is www.landloss.org, and that's a nonprofit law firm. Now, land loss does have an income limit, so if you make above a certain amount, I don't think land loss provides services, but we do have a ton, because this is where I'm barred, I have a ton of attorneys that are here that work on these issues exclusively in their practice.
Okay, I appreciate you so much answering my question.
Of course, I appreciate you being here. Thank you. Bye-bye. Any other questions? I feel like she kind of gave y'all a flavor. But yeah, it's truly my honor to be here with you all. I love seeing how much community engagement there is in this beautiful space, and definitely reach out if there's any ways in which I can assist. More than happy to do so.
We want to thank Dania for coming. Thank you so very much. I know I learned a lot. I'm sure you guys probably did too. And we also, this is called a Lunch and Learn. So we have lunch provided for you this afternoon. You can rest assured I did not do any of the cooking. Everything is good.
Oh
That's my church people there.
no! Okay.
But our lunch today has been supplied by Sophie's in Whiteville. So we have 4 different types of sandwiches for you guys, and some chips. We also have some areas set aside for you to come and eat, or you could dine on the deck. So we thank you again, and we really thank you. Thank you so very much. One last thing, if you did not sign in on our sign-in sheet, please do so. This helps not only us, but it helps Dania also. So please sign in. This helps us with our funding for projects such as this. And somewhere down the line, we will probably be sending out to you guys a satisfaction survey about today. So if you would take the time and just, it only take a minute or two just to fill it out and send it back to us. You'll help us out a lot there too.
One other thing, up in this room up here, we've got a short video on Mr. George Henry White. This is why we do what we do. So take a minute and just sit down and look at it if you got a chance for you. Thank you.
And one last thing, you've seen that we are filming today, we're videotaping this. So this presentation, hopefully with the ones in the future, will be broadcast on our website.
Oh, wow.
So yes, so if you did not get everything that you hope to get, go on the website probably starting Monday of next week. That'll give us a few days to get everything up, and share it with other people, because we're trying to get this message out to as many people as we can. So thank you so much.